and welcome to the latest episode of Certum Group's podcast, Alternative Litigation Strategies. I'm your host, Kevin Skrzalski, a director here at Certum, the industry leader in litigation risk management with the largest suite of litigation insurance, litigation finance, and legal services solutions on the market. On this program, I interview preeminent leaders in the legal industry on the hottest topics of the day. And today, I'm very pleased to be joined by Christopher Nolland. Christopher Nolland has been a neutral mediator for over 30 years, primarily mediating some of the largest and most sophisticated business, trust and probate, intellectual property, and fiduciary cases, including director and officer liability and bankruptcy trustee litigation. While Chris has mediated nearly 3,500 such cases and continues to mediate over 100 cases per year, that's not what we're here to discuss today. Rather, we're going to discuss an innovative practice area Chris essentially created and developed over the past 25 years. That is, acting as settlement counsel for one of the parties to major litigation, but in a non-neutral capacity. As settlement counsel, Chris is the strategist and advocate for the client in all things related to settlement, but with close coordination with the litigators while they continue the litigation battle and trial preparation, but undistracted by settlement developments. Chris practiced as a business litigator in New York City for 10 years, first with a major New York City law firm, and later opening the New York City office of a well-known Dallas litigation-only firm. In 1993, Chris opened his office to focus on mediation, but continued to litigate while he developed his mediation practice. Chris was asked to become the coach of the SMU Law School negotiation team. Later, he became an adjunct professor at SMU Law School, and for 25 years taught a 2-credit course in negotiation every spring semester to second and third year law students. Amazingly, even though this class was scheduled for 8 a.m. on Fridays, it was nearly always oversubscribed. About 25 years ago, Chris conceived and developed the idea that the litigation and trial functions on the one hand and the settlement and negotiation functions on the other hand involve different skill sets, experience, and temperament, and that there were other structural reasons why those roles should be separated. His idea was adopted by some very sophisticated litigators and trial counsel and their clients, and Chris's settlement counsel was therefore born and flourished. Over the past 25 years, Chris has acted as special settlement counsel on over 100 major cases. Most of these cases involve a high 7-figure as well as 8- and 9-figure matters, with settlements obtained by Chris in a number of cases approaching or exceeding $100 million. Chris has recovered in excess of $800 million on the plaintiff side, and while harder to quantify on the defense side, he has saved his clients at least tens of millions of dollars, if not more. About 65 to 70% of the cases that Chris works on as settlement counsel are on the plaintiff side, and about 20 to 30% are on the defense side, although there's often claims and counterclaims that are involved. Chris eschews the hourly arrangements in a settlement counsel practice because he believes that compensation should only be based on the results that are obtained. Chris has been recognized for developing the innovative settlement counsel model by numerous legal publications. He's been recognized as a trailblazer by the American Lawyer, a Lifetime Achievement Award by the Texas Lawyer for his settlement counsel practice, by the National Law Journal as an ADR champion for his settlement counsel practice, as well as other legal publications recognizing the unique model, including the Texas Law Book. It is truly a privilege and honor to have you on the program today. Chris, I thank you for joining me.
Kevin, thanks.
Chris, I think it would be best to start by backing up in your career a little bit and just asking you, what was the genesis of your path to becoming the settlement counsel trailblazer that you are?
Well, I think somewhat like many things in life, it was somewhat serendipitous. But as the saying goes, luck favors the well-prepared. And I've always had somewhat of an interest in negotiation, although probably didn't realize it when I was in college or even law school. Interestingly enough, when I was in New York, I was an associate in a litigation section at a major law firm. Obviously, negotiation would be part of it, whether it would be discovery issues or substantive negotiations. Although, as a young lawyer, particularly at big New York firms, your responsibilities don't necessarily swell to the very top echelons of those issues because you have a lot of seniors in front of you. But interestingly enough, I lived only about 15 to 18 blocks from my office. And I was walking home one evening and stopped at a Barnes and Noble bookstore on my way home. And I stumbled onto a book called You Can Negotiate Anything by Herb Cohen. And while it's not the deepest or most academic theoretical book on negotiation, it's quite a good read and really stimulated my interest in negotiation. And I focus on that. And at the time, this would have been in the 80s, mediation had not yet really become as well-developed standard operating procedure for resolving matters. Probably would be another 10 years before that really started, both in New York, Texas, Florida, and California were the epicenters. But I developed a real interest in negotiation, largely stimulated by that book. And so I would volunteer to get in those negotiation situations, even if it wasn't a formal mediation. And later on, when I opened the New York office of a Dallas firm and ultimately moved to Dallas, at that point, mediation had more come into vogue in the late 80s and early 90s. And even cases I wasn't involved with, I would volunteer or maybe push my way in to taking the lead at the mediation and going to the mediations and assisting with them to some degree because the other lawyers were not temperamentally suited for that or didn't have the patience or just didn't like it. And so I developed that, and as litigation became more and more of a accepted practice and really mandatory practice, I realized I was well suited for that, and ultimately started my own practice in 1993, hoping to become a full-time mediator, perhaps doing some arbitration, which I still do now. And I still have a very active mediation practice. I mediate over 100 matters every year. Of course, when I started my mediation practice, you can't just start a mediation practice and be fully gainfully employed immediately. It takes anywhere from 2 to 5 years to fully develop a mediation practice. So I continued to litigate and effectively became general counsel for a couple clients, supervised litigation around the country for them, and did some frontline litigation and trial work, tried cases in bankruptcy courts around the country and in other courts. But ultimately went to pretty much a full-time ADR practice. The evolving into the settlement counsel role was, again, another serendipitous event. One of my clients had a good friend who had a intellectual property case, was being handled by a lawyer who they were not really real happy with. So my job was to disengage them from that lawyer. It was on a contingency, which I did, had very pleasant and constructive talk with that lawyer about how short life was and all that. And he let it go. And I think we cut a deal where he waived his contingency fee, but he got his expenses that he had incurred off the top of any settlement. And I took that. My next job was help find some litigators for this client to pursue the IP case. I had some good friends at McCool Smith, and they were a very young firm at the time, probably open less than a year.
Wow.
And I brought it over to one of my good friends over there, and they wanted to show their appreciation. I eschew referral type fees. I don't really want to get paid for not working or not doing much work. And things were a little more loose back then about what you could do. So they obviously didn't need my help on the litigation front. They were fully capable, but had plenty of people and other resources. And so I sort of evolved into taking settlement counsel role. And I remember sort of an interesting event. I was literally down at a pretrial conference with Mike McCool a few days before the Thursday before a trial was going to be starting the following week. And the lawyer on the other side kind of yelled across the courtroom from about 20 paces away, Mike, what's it going to take to settle this case? And Mike said, you can't count that high, but don't bother me. Nolland's in charge of settlement. I'm just getting ready for trial. And the lawyer kind of grabbed me at the end of the pretrial and said we should talk. And we were up to about 3 in the morning at my offices and got the case settled. And that Mike know, and he was working on trial preparation to the moment we called him on the phone and said, pens down.
We got it. Yeah.
That role naturally evolved. I worked on some other cases with them and with other lawyers, and that role just naturally evolved.
That's a great story and an excellent history and background. Thank you for that. So, but it's interesting how you went from being like a litigator to mediation to a whole ADR practice to settlement counsel. There's probably a lot of people who are going to listen to this program and they don't know the differences. So can you explain really like what is settlement counsel, like Settlement Counsel 101, and how that role differs from a traditional mediator or just a litigation attorney?
So a litigator, obviously, by their nature, and I'll use him or her or whatever, I'll mix it up a little bit, but they are litigating. They are advocates. They are champions for their client. Their job is to persuade the other side how bad the situation the other side is in, to persuade the court that they are righteous and that they are legally correct and that the facts, the law, and the analysis will favor their client, ultimately to persuade a fact finder, either a judge on a bench trial or a jury on a jury trial, that given the instructions, if it's a jury trial, that the judge gives to the jury and applying the law, that their client should and really must win. And not only is that legally correct, you really want to help convince them that's factually and equitably correct as well. And then you have to do the same thing all over again with an appellate court to hold on to your result in the trial court, or if things don't work out in the trial court, you want to convince the appellate court that they should change that result or at least order a do-over.
Right.
The interesting thing about that is that role has traditionally not been separated from the secondary role of lawyers, which is traditionally litigators, since they're handling the case. And I grew up in a small town, so it's not unusual to have 1 or 2 person law firms. Well, the lawyer will handle the case and they will talk about settlement. And lawyers traditionally talk about settlement. And of course, most cases settle. Some 95% of cases are resolved without trial, either through dispositive motions or, if not dispositive motions, by settlement. So most cases get resolved by settlement, and the litigators traditionally did that. And I would kind of use as a parallel the time before mediation became standard operating procedure and pretty much embedded, certainly in most large metropolitan jurisdictions around the country. Lawyers, when first mediation first came on the field, and I'll talk about the difference between the mediator and settlement counsel in a moment, they would say, why do I need a mediator? I've always had my own discussions, settlement discussions. I don't need anybody to help me out. And they realize ultimately the value of mediators. There are certain things mediators can do that lawyers just can't do in terms of floating trial balloons and some other stuff, and having direct talks with counsel and the clients on the other side, or maybe even your client if there's a client control issue. Settlement counsel is different than a litigator. When I'm settlement counsel, I don't get involved in the litigation directly. I don't argue motions. I don't take depositions. I don't write briefs. I don't argue appeals. I don't argue motions. I don't do the trials. I may toss in my opinion, probably a little bit of like an old fire horse. When I hear the bell ring, I kind of can't help myself. So I may add some 2 cents about trial strategy or substantive legal stuff if I think I can add some value. But really, the settlement counsel is different than a litigator because they're not litigating. They're different than a mediator because I'm not neutral. I'm trying to get the very best deal for my clients. A mediator is just trying to get the case settled, and obviously has to have an equilibrium and neutrality vis-a-vis both parties. As a settlement counsel, I'm another advocate for the client. It's just that I'm not doing the trial advocacy or the litigation or appellate advocacy. I'm doing the settlement advocacy, which is being able to read the room on the other side, develop a settlement strategy, recognizing what tactics will work and won't work, obviously having some pretty good sense of the substantive, factual, and legal issues to help evaluate the case, and to give the client guidance and advice about whether a proposed or possible settlement is appropriate. And maybe even help the client get through some emotional or intellectual issues relating to settlement. Mm-hmm. So a settlement counsel is not neutral. They are trying to get the very best deal for their client, recognizing that they may have a better understanding of the dynamic that's on the other side. There's also different, I will say, sometimes people get mixed up, the concept of collaborative law, where you'll try to negotiate and then you drop out if a settlement is not reached. A settlement counsel is not the same as collaborative law either. There's a little bit of similarity, but in collaborative law, if you don't reach a settlement, you agree you will not be the litigator and you drop out. Settlement counsel is so those kind of a linear progression. You'd have collaborative lawyers. If that doesn't work, then you go back to the traditional litigator mode. That's really a creature almost exclusively in the family law context. Mm-hmm. Settlement counsel is really two parallel tracks. You have somebody working, a bunch of lawyers typically on the cases I work with, working on the litigation side, getting ready for trial, all the stuff of litigation. And I'm on a parallel track working on settlement, developing the strategy, figuring out what the best timing is, developing a settlement model, figuring out who the best point person is. So those are really parallel tracks. And maybe a good way to think about it is if you're in a major international crisis or even a war, you have generals and you have diplomats, and they work on parallel tracks. Diplomats don't direct the war, and the generals don't direct the diplomats in their diplomatic efforts.
That's a great analogy. Yeah. Yeah, that really clarifies the bifurcation of the roles and the time efficiencies that are built, where one person can continue to just advocate and argue while there's a whole other person over here that's just working towards settlement and resolution in an efficient manner, and you don't cross them. It really helps keep the litigator focused and not distracted by settlement negotiations.
Well, and it's not just a lack of distraction, it's the signals you send to the other side. It's the time constraints. Litigators always have their hands full with the litigation concerns. When you're involved in the very highest stakes litigation, there's massive amounts of information to assimilate and organize, even with the help of AI. Well, that makes it a little easier. You still have to do quite a lot of critical thinking. You have typically significant discovery disputes, electronic discovery issues, deposition type issues, all those things. You have dispositive motions. Really, as a litigator, and I think back of my 20 years of being a frontline litigator, you really, almost no matter how big your team is, you can have a 20-lawyer team on a case, and it still seems you never have enough time or people to get everything done. So by your nature, settlement thoughts and end up being done on the fly and being a stepchild and without the really deep thought and preparation that really should be brought to bear, and the planning that should be brought to bear. And you have a situation with litigators where you have different skill sets are involved.
Right.
Litigators tend to want to, I mean, obviously they need to know the rules of evidence and procedure, and they need to know the substantive law, but litigators by nature need to be aggressive. They need to push because otherwise they'll get pushed around by the other side.
Right.
They need to be aggressive. They need to send out certain signals. Certainly, you don't necessarily need to send out a signal that you're a jerk, but you certainly need to send out a signal you won't be pushed around. And that may be interpreted as less accommodating. And in fact, sometimes very, very hard positions have to be taken in litigation. And not that anybody's kind of like that old Dave Mason song. Sometimes there ain't no good guy and there ain't no bad guy. It's just you and me, and we just disagree. The litigators sometimes often disagree. Sometimes it gets very personal, or they're channeling their client's personal feelings of being wronged or unjustly accused, depending which side of the docket you're on. And the lawyers sometimes take on that client's persona, and they can barely talk civilly to each other, much less engage in constructive settlement negotiations. So the litigation model doesn't really lend itself to it. And then, as you mentioned, the litigators not only don't want to be distracted, if you make a settlement overture, the other side may misinterpret it, or you may be worried that they do. And I can't tell you how many discussions I've had when I was a litigator and even a settlement counsel. Well, if we make a settlement overture, will they think we're weak or anxious? Or
of course,
I've been in mediations, and I would say 10% of the mediations I'm in, somebody will say, well, they asked for this mediation. They must really, really want to settle. And I have to explain to them when I'm acting as a mediator that initiating settlement or initiating a mediation, which is really initiating settlement talks, is not a sign of weakness. It's a sign of strength in certain respects. And it's a sign that you are comfortable having those discussions. And of course, people misinterpret that.
Right.
You get other issues with litigators. One, their judgment sometimes gets distorted. They live and breathe the case, and they either become true believers or they think by the force of will they can do it. And that doesn't necessarily lead to good dynamics for settlement.
Or they may not see some weaknesses because they're so focused on over-advocating that they're missing out on these points that should.
They drink their own Kool-Aid and
You're drinking the Kool-Aid.
believers. And they can't see it from the other side. And then you have what you kind of in a different way, if they're also discussing settlement, and sometimes people deliberately do this to the other side, particularly as you're getting close to trial, they'll engage in settlement, and the litigators think, oh, this case is going to settle, so they mentally are not quite prepared for that last push to get ready for trial, or they figure it's going to settle, so they don't get ready. And of course, that's not good. It really makes settlement less likely. So by not being involved in settlement talks, the litigators don't get a feeling, hey, the case is going to settle. I don't really have to get ready for trial.
Okay.
And of course, you have time constraints as you're getting ready for trial.
Yeah.
And then finally, litigators just temperamentally are not necessarily suited. Some of the things that make you a really great litigator, the willingness to push hard and to take a chance and to do the Hail Mary, which is what trials often are.
Right.
Not necessarily the things that are good things for settlement. And very few litigators, and I certainly won't say none, there are some Renaissance people who can do everything. But they don't necessarily have the experience in settlement and negotiation. They haven't understood the academic and the theoretical basis, which really help you out. They haven't had the hundreds or thousands of hours of negotiation experience. And if you use the old 10,000 hour rule, if you want to have 10,000 hours of negotiation experience, that's 1,000 days of negotiations, which very few litigators will have.
That's a lot.
Yeah.
I think the separation of the roles as you describe them and the reasons why make great sense. But let me ask, why not just designate someone on the trial team to focus on settlement negotiation, or even maybe someone else at the firm that isn't necessarily, like on the trial team, or that's more of maybe a neutral, or even maybe having in-house counsel sort of take on the role as settlement counsel? And is that ever suggested?
That does come up, and I've actually seen it where in-house counsel can sometimes play that role, maybe sometimes in-house counsel to in-house counsel, but even then it's not optimum. In terms of the trial team, a couple things happen. One, they still may not be very good at settlement and negotiation.
Well, sure. Okay.
Two, you're part of the trial team, and inevitably you're going to get sucked into the litigation team when things get hairy and busy
Okay.
and all that. And
Yeah.
that causes two problems. One is you don't have the time to focus on it. Secondly, you're going to be associated with the trial team. And so you don't have that kind of third party. If you're going to be dissociated, for lack of a better word, with the bad cops, so it's hard for you to be the good cop.
You're still in the bad cop team. Like
Right.
you still are.
Yeah, you
Yeah.
still are, and any hard feelings which may have developed will bleed over to you. You can't be disloyal to your team members. You got to back up your fellow litigators, and really by having somebody from a separate firm, it really informs the other side that this is a separate process. It's separate from the litigation proc, and there's a clear compartmentalization and a clear, I don't know about Maginot Line because that wasn't very successful in World War II, but there's a clear Chinese wall between
Okay.
the litigation and the settlement. And then in terms of having in-house counsel do it, in-house counsel, one, again, may not be all that oriented towards settlement in terms of the academic theory, the strategies, the tactics. They may not have that much experience. If they had a transactional background, they may be a bit handicapped dealing with litigation matters. If they have a litigation background, they still may have some of that uber aspirational mindset to it. But secondly, in-house counsel is the client. And so essentially, if you're having in-house counsel speak to the litigators on the other side, you don't have that buffer. You can't do the what if limited authority strategy that you can use. So if in-house counsel is doing it, they can't say, well, let me check with my legal department. They are the legal department.
They are the legal department. Like it's, yeah, not let me check with my client. Yeah, there's no wall there.
They're too closely associated with the client, and they can't do, I'll see if I can sell it. They could do that a little bit by talking about the bureaucracy or levels of authority they have. But if they hint that they can do something, that's almost the same as making an offer, and they don't have that buffer.
Yeah, and I think the trends lately with in-house counsel has been that the departments have been shrinking and budgets have been shrinking, and they're really forced to do more with less. And they're handling litigation, they're handling transaction, they're handling regulatory, they're handling human resources. So, yeah, they don't have the time, really, the bandwidth to do that, even if they had the background or the skill set. So I think that all makes perfect sense. So in terms of timing with the litigation, though, in our business, we work a lot with settlements. I mean, one of the solutions we offer is class action settlement insurance to transfer outcome risk in large nationwide class action settlements. And most people are waiting to discuss settlement until they're pretty far down the road and they've gotten past some dispositive motions. And we always say, maybe just think of the cost benefit analysis of bringing us in earlier to try to propose some structures. Do you hear the same thing, or when do you think is the optimal time that outside counsel or their client should bring you in and involve you? Is there a certain time period, or are there different like benchmarks during the course of the litigation that make more sense than others?
Well, that's really two questions. One is
Yeah.
what typically happens, and I think typically people wait too long to raise settlement, and there's a balance. You don't want to look too anxious, but I think people worry about that too much. Again, I think if it's done right, it's a sign of strength. For instance, when I get involved in cases, say now may not be the time to discuss settlement, but there may or may not come a time. I'm the guy. And that just leaves the door open, and that way you don't have what I'll call the first overture dilemma, where both sides want to talk about settlement, but everybody's afraid to raise it.
Yeah.
But I think people wait too long because of that. Now, that could be lots of different reasons. If you like to litigate and all that, well, you can't be a great litigator or a great trial unless you can litigate some cases and try them. So if you settle them too early, that doesn't necessarily work in terms of how you want your career to evolve and having some nice big judgments you can put up on your wall. And if you want to be a great trial lawyer, you're not going to get there by settling cases. So there may be a subconscious bias about it, and then and no offense to my brethren, because 99% are straightforward, upstanding, good people, but we've all had discussions when we've been lawyers, whether we started out and still are litigators, or even transactional lawyers or in-house counsel. Is the case ready to settle? Has the lawyers on the other side made enough money yet? We've all heard that before. And so
Right.
again, as Charlie Munger would say, you show me the incentives and I'll show you the result. Well, again, I don't think you don't necessarily get big, great job, well done from your partners at your law firm if you settle a case before you make any significant fees on it. So I don't think that'll add to your points at the end of the year when they're figuring out compensation. So again, that's a subconscious thing. It's not really a problem with really great lawyers and sophisticated lawyers, because most of those lawyers have more work than they can do. But it can be a factor in some cases. So I do think it's thought about too late from and I would say most cases I'm brought in at Settlement Counsel, I'm brought in later than I would like. Usually after a case has been going on for a while, people have gotten sick of spending legal fees, or there's been a particular litigation event. There's a dispositive motion scheduled, a trial is coming up, there's been a really good or bad deposition, or ruling by the court on some issues, or maybe a new legal development. Some appellate court has issued an opinion that could impact this case, and I'm brought in then. My preference is to be brought in before the lawsuit's even filed. Even if we decide that we don't want to make a settlement overture pre-lawsuit, I want to start getting planning for it. And I need to be up to speed, because settlement sometimes happens early in lawsuits. And I need to be prepared and up to speed. My schedule is pretty full. And if I'm not prepared and up to speed, I can't do it. I got an opportunity to get involved. Don't mention the case, but literally in $1 billion case about 9 months ago. But it was coming to a head in 10 days. And my schedule just didn't allow me to get involved, which was really unfortunate, particularly unfortunate for me, and really a really interesting case that I would have loved to have worked on, but my schedule just didn't allow. So one, I need to be up to speed for it. Two, I need to develop a settlement strategy early on. Again, that's not something you do in 2 days. Three, it's often better to see if you can develop a little bit of rapport with the other side, so they understand your role. Four, if I'm brought in just before settlement, it may look, oh, they brought somebody in to settle, they must be really anxious. Again, misreading the situation. But if I'm brought in early and I'm just there and it's standard operating proceeding and there's no precipitous event, it makes it much more normal, and they don't misread what's really happening. And then if I'm brought in early, I can do things that will, instead of being reactive, I can be proactive and maybe setting up a settlement dynamic. And so as being brought in a month before the case is going to trial, and your ability to develop a strategy and implement it, or maybe some approaches just are no longer viable because we're too close to trial for lots of reasons. So the earlier the better. And I prefer pre-litigation. And there are those cases that can settle before litigation, because one of the big values in a settlement for a defendant, and again, I'm probably on the plaintiff side 70% of the time, is not having a lawsuit filed and have it be a public record, particularly if it involves fraud claims or breach of fiduciary duty claims or professional malfeasance claims, and a variety of other things, because those kinds of claims, just the mere filing of them, can have an untoward impact on a defendant's business. And by not having that happen, there may be more value to a settlement before a lawsuit's filed than afterwards.
Yeah. A lot of the points that you make resonate with me in our business and our practice as well. Sometimes we'll have a conversation about settling a case or ensuring an outcome, and then we don't hear from them again for like 2 or 3 more years, and now they've lost dispositive motions, or if it's a class action case, the class is now certified, and quite frankly, the price of poker has just increased exponentially. Along with the fees that you paid, you could have settled for a fraction of all of those costs 18 months ago.
Right. And you have the plaintiff's fees, and they're going to want more on the settlement. You have the defense fees that they've
Absolutely.
spent. And then, it's obviously I closely coordinate with litigation counsel. I don't keep them in the dark. They are a resource for me, and I'm a resource for them, and we cross-fertilize each other. We stay in our lanes, but we cross-fertilize it. They, with very rare exceptions, they will know in real time what's going on with settlement, and I, of course, need to know in real time any litigation developments. Occasionally, I'll have a client or in-house counsel say, I don't want the litigators distracted right at this moment, but that's usually when we're very close to trial or some other tipping point. So that ability to coordinate with counsel gets harder if I'm brought in just before trial when they're going crazy trying to get ready for counsel. They really do not have time to go out and have lunch with me, and we can talk about settlement and the personality.
Get to know the case and the people.
Yeah. So it allows me to do a better job as well earlier on. And again, it becomes, this is our standard operating procedure. Don't misread anything into this. We're just separating these 2 roles.
Yeah, so that leads me then to ask, when you're talking about, engaging with counsel or maybe engaging with opposing counsel, what's the biggest resistance that you get when trying to come in as settlement counsel? Are there any challenges, like to the litigators? I guess to back up, and maybe this is another question, like who hires you? And then are the actual litigators that are counsel of record not very warm to embrace you because someone's coming in and you're basically now taking over this lead role in negotiation and settlement when they're advocating and arguing and they're thinking, who's this person? And then on the flip side, how do you get opposing counsel to work with you when they know you're not a member of the firm and you're not on the trial team? That's like this third party's coming in, but you're not a mediator. So what's the biggest resistance you get in managing the human dynamic of all of this? So
let me answer the questions, and I don't know if I'll do it quite the order you mentioned. In terms of who hires me, ultimately, of course, the client hires me. The lawyer, I would say about 2/3 of the time, maybe more like 3/4 of the time, it will be the lawyer's idea Either they know me or they've worked with me before, they heard of
Okay.
me, but I'm hired by the client, not the lawyer. So I'm not the lawyer's lawyer. I'm the client's lawyer to help with settlement. Now,
Mhm.
sometimes the the law firm, for instance, a lot of stuff I do is on contingency. Sometimes a law firm will tweak their contingency fee, not share it with me, but they'll tweak it, they'll lower it to allow the client to give me a contingency fee, but I'm still working for the client. Sometimes I'll work out separate arrangements with the client. Sometimes the lawyers and client will agree my fee will come off the top, but the client hires me, but I'd say around 3/4 of the time, they will hear about me through lawyers, through various things. I just got a call yesterday about a new case, which I'm going to be reading about this. Have about 3.5 inches of documents to read this weekend to see
Okay.
if it's the right case for me and I can add value. But the client heard about me through the lawyers who had dealt with me. Actually, in that case, as a mediator, but they were aware of my settlement counsel practice. In terms of the opposing counsel, I'll answer that next, even though that was towards the end. It's how do I get them to work with me? They don't. I won't say they don't really have a choice, but the opposing counsel doesn't get to choose the other side's lawyer. So it's
Oh, okay. Sure. Sure.
so that I am what I am, and in fact, they should um, presumably embrace the fact that I'm there. One, because sometimes because of the strained relationships between litigators. Um, Two, what I'll call the natural advantage I have in the good cop, bad cop, well known but very effective negotiation strategy or tactic, whatever you want to call it, the good cop, bad cop. That's probably the most well known negotiation approach that there is. And as well known as it is, it's still extraordinarily effective. And particularly it's extraordinarily effective when I am truly a good cop. And they will know that I won't miss cue on settlement. If I say I can get something done, I won't be one of those lawyers who say, I think I can sell my client on that and just kind of trick somebody to do that or mislead them. So I have, my own integrity and reputation I bring to bear, which
Yeah. Okay.
that makes it easier for them. I, in fact, once was involved in a case. It was a professional malpractice case involving a very large law firm. I had friends there, and I called them up and saying, they weren't involved in the case, but other partners were. It was a 500+ lawyer firm. And I said, I won't, I've been asked to be settlement counsel in this case. Your firm's involved, but if it's going to ruin our friendship, I don't want to do it. And they said, no problem, because we know you're going to try to get it done. You're not trying to go to war. You're part of the solution. And I think most lawyers, obviously that was an unusual dynamic, would recognize that they can deal with George Marshall, the great general and great Secretary of State, or they can deal with George Patton, who definitely is not the negotiation type. His idea of negotiating is to shoot you and then discuss negotiation, a resolution. And
Yeah.
so they recognize I'm better to deal with. The more problematic or more challenging, maybe more accurately, issue is how do I get buy-in from the litigators? Sometimes I don't. Sometimes the client imposes me on the litigator, and then they
Okay.
come around eventually. Sometimes the client and the litigators make that decision. The client raises it with the litigator. I think there's a few dynamics involved. One is why do we need settlement counsel? I've never done it this way before. Just a natural stasis of, why change it? If it ain't broke, why fix it? And of course, they may think it's not broke, but it probably is, because they've had settlement negotiations that they've been successful with before. And so therefore they've been successful. So why do they need a settlement specialist? And the answer is they may think they've been successful, but they may have gotten subpar results and not even know it. Or they may have had settlement negotiations and they blew up and they say nobody could have gotten it settled. So the fact that it blew up because the other side were jerks or assholes to use a technical term. Nobody could have done it, and maybe there were some things that could be done. So again, it's similar to that dynamic when mediation first became a pretty much standard operating procedure.
Yeah.
That is actually not that hard to get by. What's harder to get by is sometimes relatively big egos, and I think by nature, litigators,
Sure.
trial lawyers, to be successful, you have to have big egos, and I'm not even saying narcissistic, but just big egos, and that you're very good at what you do, and therefore you're very good at everything, and there's that nature in litigators. There's also a dynamic of saying, well, if I let this person, be settlement counsel and control of it, I'll lose control over the case, or at least an important aspect of the case. And again, lawyers, and I probably fit in this category a little bit, are control freaks by nature, and that's a very temperamentally and emotional thing to give up. And then you have the issue of, well, if I do the negotiation settle case, I'll be the hero. If somebody else settles it, they'll be the hero, and I want to be the hero. And I think ultimately they realize that the reason the case settles, or at least a reason the case settled favorably, is because they're doing such a great job on the litigation and trial preparation that the alternative to settlement is awful for the other side. So a settlement, even if somebody else is the point person, actually makes them the hero. And once they realize that, they can get behind it. Sometimes they don't just change. Sometimes they're worried about losing the client. That's not a problem for me. I think it would be if, say, I was a lawyer at a 1,000-lawyer firm. They would be afraid of losing a client. I've been on my own as a solo practice lawyer for over 30 years. So Kirkland and Ellis or Sullivan and Cromwell do not have to worry about losing their client. To me, that's not an issue.
Sure.
They sometimes worry about additional costs and all that. Ultimately, it's somehow the client bears it, even though they may cut their fee to help make it work if they're involved in a contingency case. But ultimately, somebody's going to have to deal with settlement. And this is true for both the lawyers and the client. If they're relieved of that, that means less manpower that they have to bring to bear, or less hours a client has to do it. And two, it'll be more efficient than if it's done haphazardly. And then there's that little bit of probably the feeling among some small minority of lawyers, and maybe mostly subconscious, if the case settles, I want to be the one to decide when it settles and when my fees end. Again, I think that's generally not a problem, and if it is, more of a subconscious problem than a conscious thought of wanting to churn the case. But everybody worries about that.
Definitely a ton of dynamics to manage, given all the parties on both sides and the lawyers and the in-house team and how to manage all that. Very complex. It sounds like you've mastered it over decades of experience. I bet you have some really great stories you could tell. So after handling hundreds of cases as settlement counsel and thousands as a mediator, without divulging any names of the innocent or guilty, what are some of the most memorable stories or moments that happened during settlement negotiation?
I can think of a few, and some and have to be discreet. I was involved in one case. It was up in New York, meeting with some folks. I was hired as settlement counsel, and we had actually a pre-litigation settlement meeting, and the other side, we did not have a mediator involved, and we met at a hotel in New York. And I was essentially, they understood my role, and I was essentially going back and forth between my room and my clients and the litigators, and the other room with their lawyers. And if you didn't know my role, you would have thought I was a mediator.
Right.
That's what it looked like. And to the point where one of the business people said to me, said, now you're going back and forth. You're not a mediator, are you? Because they didn't quite understand it, the client did, the lawyers did on their side. I said, no, I'm not a mediator. I'm not neutral. I'm trying to get the best deal for my client I can, but I'll be fair. I want to be fair. I want to get a good, I want to get it's not my job to make this as painful and difficult for you as well. And I'm going to be give my client good advice about what's an appropriate deal. And so it shows you how easily people can sometimes conflate the mediator role with the settlement counsel role. And there is a little bit of overlap because they both involve being a straight shooter. They both involve keeping your credibility. They both involve lots of patience. They both involve letting people sometimes vent, sometimes very loudly and very vibrantly and very robustly and
Colorfully.
and maybe more than you'd really like.
Okay.
Both understanding that there's a time to push and a time to pull back. Both having a good understanding of the dynamics and how to read the room and what's going on with people. Recognizing some behavioral economic issues like sunk cost issues and cognitive dissonance and the endowment effect and a variety of other things. So there's a lot of the same skills involved, but the approach is very different. Other weird things that have happened, I was involved in one case which ultimately settled for in excess of $100 million, where we'd gone to trial, ended up being a mistrial. It was shortly before the holidays, like the day before Christmas or maybe 2 days before Christmas.
So there's urgency sets in.
Principals were there. We were down at the courthouse. The judge told us to have settlement discussions. And again, I was going back and forth with the lawyers on the other side. And there's business people and the business person's what I'll call chief lieutenant. I can't recall whether he was a lawyer, plus the lawyers were there. And at one point, the chief lieutenant said to me, "You're just a car salesman." And I looked at him, and I think he thought he made a remark that was an insult of some sort. Or
car salesmen are pretty good, can be pretty good salesmen.
And I said, I'm going to take that as a compliment. Because car salesmen are some of the best negotiators there are. Now, some car salesmen use that in a way that's not honorable, but the good ones don't. The good ones who have repeat customers and all that, they want a good deal for the customer and they want a good deal for their client. In the case of a car salesman or car sales lady, that would be the car dealership. They want a good deal for everybody. They don't want to screw the customer. Because they want that have a repeat customer, and it's a small world, and you'll come across them again. But they also obviously have obligations to the dealership. I don't so much have repeat customers on the other side of settlement negotiations and litigation. Occasionally I do, but I do have repeat lawyers I see, and I do have repeat clients I see.
Okay.
So I'm going to maintain my credibility. I'm going to be honorable. I'm going to do it the right way. And I think that's actually how good car sales people do it as well.
I would agree with you, definitely.
So lots of very interesting stories. Some I can and can't talk about. Some of my very best results have happened just by one move at a mediation on a case I was involved with, a D&O case. We got an extra $5 million just from one little interplay at the very end of the mediation on a D&O case. So sometimes it involves lots of strategic planning. Sometimes it is something that pops up at the last moment. And of course, you can plan and sometimes make those things come up at the last moment, or you just by your experience and knowledge and temperament are prepared to kind of innovate and be like a Marine and go with the flow a little bit.
Yeah. Certainly, certainly. And Chris, I know I've taken a lot of your time today, and I really appreciate all of your deep and valuable and robust insights. But I have a few more things I want to ask you before we close up today. Where do you think the practice of settlement counsel is going over the next, I don't know, 10 years? And what advice would you give somebody, maybe a young lawyer or a lawyer in the middle of their career, who's thinking about becoming a mediator or even ultimately trying to develop a settlement counsel practice?
Let me answer the first question. Where do I think it's going? I thought it would be further along now than it is. It has developed some. I've been at it for over 20 years. I thought it was going to have somewhat the same trajectory as mediation, become maybe not quite as much, but because obviously a court can't tell you to get settlement counsel. It can order you to mediation, though. But I thought it would pick it off a little more. It has increased, and I've probably come across it a dozen times or more. There's an article at the University of Saskatchewan Law School that I was a resource for, where they talked about settlement counsel. You see it more and more. I would say 20 years ago, when I first kind of dreamt this idea up, I would get, I'm going to be a little colorful, I would get a WTF comment. What are you talking about?
Yeah.
And nobody heard about it. Almost like mediation, if you raised it 50 years ago, the reaction.
Right.
And I will say now, I do not get the, what are you talking about? I've never heard of that look or inquiry anymore. People have generally heard of it and understand it. They may not have used it, but it's not a foreign concept to them. I think more and more, I don't think quite with the speed that mediation happened, it's going to become standard operating procedure among, and it's only appropriate for some cases. Obviously you don't need settlement counsel on a fender bender case. Doesn't make economic sense. Or on $100,000 or $500,000 business case, it probably doesn't make economic sense. At least it doesn't for me. Virtually all my cases are high 7 figures, 8 figures, 9 figures, occasionally over $1 billion. I've had at least 3 settlements on the plaintiff side over $100 million, and several in the high 8 figures.
Well, there's just not that many cases like that are that size. I mean, I think if you search the federal docket and you try and look for every case that's settled for over $100 million in the last 5 years, there's not a ton.
Well, of course, that being said, a lot of settlements, you don't know what they were.
Oh, well, okay, sure.
So, sure. And the damage models are not often decipherable by looking at what's been filed. Expert reports.
Good point.
Filed.
Yeah.
And of course, pre-litigation stuff you don't know. For me, I would say, unless the case has a realistic settlement, not a pie in the sky settlement value, where you toss on all kinds of punitive damages and extremely unlikely consequential direct or indirect damages. But if it has unless it has a real settlement value of at least $5 million, it's probably not worth it for me to get involved.
A minimum threshold.
It would work. But I would say most of my cases tend to be in the high 7-figure to $30 or $40 million range. But again, a number settled for more than. And so I'm not saying claim damages of more than 100 million. Actually, the settlements were more than that. On the defense side, it's hard to figure out exactly what's in play, because typically my clients, if I'm working on the defense side, disagree with the damage model. But unless there's an opportunity to save significant 7 figures, it probably, again, doesn't make it worthwhile get involved. I think I've done 1 or 2 cases early on where the damages were more in the $1 to $2 million range. To some degree, because I was just starting out, and to some degree, there are accommodations for a friend. But in general,
That makes sense.
there
Yeah.
has to be a significant case to make it worthwhile. And I think really to make most settlement counsel stuff worthwhile, they're got well known in some of the tobacco litigation way back in the 90s
Right.
and all that. They had settlement counsel, and some of these large tort cases, there'll be national settlement counsel and that sort of thing. But that's really different than what I do. They're more focused on what I'll call the asbestos settlement model, making grids and kind of cookie cutter settlements with hundreds of thousands of potential claimants or plaintiffs. Typically, my cases involve, single case settlements.
Understood. But I would imagine, yeah, given the proliferation of litigation and how basically like the filing number, the docket filings just continue to increase year over year, and the amount of mass torts, there will be room for this practice area to grow over time. I think that just makes logical sense.
Right, and not every case is suitable for settlement counsel. Not every case is suitable for me for settlement counsel, and it's not a one size fits all thing. And not every case is my case. But I may not want a case either because I don't like the merits. Sometimes I don't like the client, and not that I necessarily personally dislike them, but I don't think they have good judgment, or they don't have responsible expectations, or they don't listen to reason. Not that they just do what I tell them, but
Sure.
I need to engage in a fair and responsible and thoughtful intellectual dialogue about some stuff. So, I'm careful in the cases I pick. I have obviously a limited amount of time and resources I can spend, and taking on a case that is a good case with a bad client is not something that is high on my to-do list.
Of course not, and I think that makes great sense as well. So, before we wrap up, last but not least, question: if you didn't have a successful settlement and mediation practice, what would Christopher Nolland be doing today?
Well, I think three possibilities. One,
Okay.
I was an appellate law clerk after law school. I like the intellectual challenge of doing appeals. So I think if I hadn't gone into the ADR world and still wanted to practice law, although it's not quite as clean as I think I thought it was, that is a good sentence, as I think I would like to be an appellate lawyer because it's a little more ivory tower-ish. You typically not involved in discovery disputes and
True.
yelling at each other at depositions and saying that's improper and this and that. It's not as friction-filled, and it's a little more intellectual. That's not entirely true the last 20 years, because it's relatively normal in the last 20 years to have appellate counsel come down to the courthouse during trials to work on the jury charge, maybe even some evidentiary or procedural issues, making sure you preserve error for appeal. So they're sometimes down in the thicket in a way that they didn't used to be. If I had my choice, I would be one of those appellate counsel that after somebody lost a case or won a case and they want to hold on appeal, they would call me up and say, I want you to work on this case. So I wasn't involved in the thicket of the jury charge and preserving appeal. I would just be able to talk about how somebody else mucked it up, and I was then going to save them. So
I like that idea. That's good. I like that.
That's probably what I would do as a lawyer if I had my druthers.
Okay.
And pretty fun, intellectually challenged, and a lifestyle that would make sense for me. You work hard, and you have some time constraints, but you generally don't have the time constraints and lack of control of your calendar that a trial lawyer and litigator has. Mm-hmm. If I wasn't practicing law, I think I probably would have gone into the investment banking area, because it has some of the same dynamics and some of the intellectual challenges, and some negotiation in business transactions and all that. And then if I didn't do that, I think I'd probably want to have a hot dog stand or be a deli guy.
Oh my goodness.
So, because one, you get to be around people, and you get to make lots of friends. Generally, people
And
are,
where would that be? Would you be in Dallas or would you be
well,
doing that in New York
for
City?
some reason, if you think about a classic Jewish deli, they never really have taken off in Dallas. There's been a few here and there, and I think there still is one or two, but they never really taken off. There's been a few that have started. Houston's done a little better. Obviously,
Okay.
New York is epicenter, but there's
Yeah.
other places that would do it. But at least when most people come to the deli and they're getting a good pastrami sandwich, they're in a happy place, and you get to schmooze, and of course you get to eat well if you own the deli.
Oh,
That
sure.
that being said, I'd probably be about 400 pounds if I owned a deli, so that probably wouldn't be a good idea. And I do threaten my wife. We'll be driving around on a weekend or something, and I'll see a vacant storefront, and I say, "Dan, that'd be a great place for a hot dog stand." And usually,
Oh boy.
she usually either threatens to or actually does hit me on the side of the head when I say that. So, but one of those
Well,
things, or something very people oriented.
I love those answers, and the last one is great fun. I think that's interesting. So, again, Chris, thank you so much for your time today and for sharing all of your valuable insights and for spending so much time with me. I think this was an excellent, very robust program that provides just a lot of great insights into the settlement counsel practice. Now, if somebody would like to get a hold of you to discuss your practice, what would be the best ways to reach you?
The best way is I have a very robust website, which I'm actually proud to say I built myself when I was bored during COVID.
Oh, terrific.
It's I just and I managed to snag as a domain name my last name, so it's www.nolland NOLLAND.com, and there's various pages on there, just a general profile page about me, and there's a page about my mediation arbitration practice, and there's a separate page about my settlement counsel practice,
Okay.
which has really an in-depth discussion about some of the issues we talked about today, as well as 6 or 8 articles about the practice by Texas lawyer, Texas law book, American lawyer, National Law Journal, uh, and some other folks as well. Some articles I've also written about settlement strategy,
Yeah.
negotiation as well.
Yeah, and they are excellent articles, posts, and publications. So
Right.
thank you for
And
that.
my email and phone numbers are all on there. And I'm a little bit OC by nature. So if you send me an email, I generally try to respond within 24 hours.
Terrific. All right. Well, thank you again, Chris.
Kevin, great to talk with you.
Last but not least, I want to thank the audience for listening. If you're watching this podcast, you probably saw us on LinkedIn, X, YouTube, Apple, Spotify, Stitcher, or one of the other multiple podcast outlets. But wherever you found this episode, please like and subscribe. And if anybody has any questions about what Certum Group does, you can visit our website at www.certumgroup.com, and you can read about the various different types of litigation finance, litigation insurance, and managed services solutions that we offer. So great speaking with you today. And until next time.